Now call on our final speaker, Deputy Catherine Connolly. You have 20 minutes, Deputy. I'll advise you when you have 2 minutes left.
Thank you very much. I was just going to ask for that. Ministers, first of all, let me say that I welcome the legislation and I'm going to come back to it, but let me make a number of preliminary points in view of what was said here in the Chamber. Deputy Hildegard Naughton has left, unfortunately, and I just wanted to correct in relation to Galway. There was no charge and they weren't convicted of being prostitutes. They were actually pleaded guilty straight away, and they were subsequently convicted of operating a brothel. That will continue under this new legislation with even more severe penalties. The Gardaí, however, reckon that they were trafficked and under the control of Dublin or Belfast-based pimps, and they were nonetheless charged a fine of €200. The guards were extremely human in their response, and they said there were 4 little girls. So 4 little girls in prostitution in Galway who were being used and abused by a lot of people, and their ages 21, 22, 23 and 30. That's the first correction. The second correction is I haven't heard any single TD in this stall talk about life-enhancing experience as a sex worker. Nobody in this stall has said that. What they have done is raised serious concerns about the criminalisation of the purchase of sex because of the effect it will have on the sex workers in driving them underground. And the speakers in this stall, including myself, haven't come up with those concerns. We have read and listened to Amnesty, we've listened to the Health Organisation, we've listened to AIDS Ireland, we've listened to the Sex Workers Alliance themselves and so on. Now let me say first that I have read the Minister, the Houses of the Oireachtas report that you've referred to. I thank you for your work. I thank the Deputy Staunton for his work. I have read it. It was a huge amount of work, 4 public hearings, 800 submissions. It was specifically on one topic, on prostitution. Unfortunately, since that was produced, the evidence has moved on. And the evidence today does not substantiate the criminalisation of the purchase of sex. So I would appeal to you to look at this section and go back to it, notwithstanding the tremendous amount of work that you have done. And I absolutely acknowledge that the overwhelming number of submissions wanted to criminalise the purchase of sex. However, there were other submissions also that said, please look at this, because what will happen here is that we will actually make it less safe for sex workers. And you based your report on the Swedish model, and indeed you took your work very seriously and you went to Sweden, and I absolutely commend you for all of that work. However, the Swedish model in Norway does not stand up to scrutiny, and that is from, again, a number of very reputable organisations. So I'll come back to those 2 points in a minute. As I said, I very much welcome this bill, with the exception of the two areas which I have serious concerns about. But more importantly, there are concerns that have been raised by a number of organisations and institutions such as Amnesty, the Irish Human Rights and Equality Commission, the Centre for Disability Law and Equality at NUI, the Irish Society for the Prevention of Cruelty to Children, amongst others. And more particularly, the concerns in relation to Part 3 of the bill, which very few people have mentioned, relating to a sexual act with a protected person. I have serious difficulties in relation to that part of it, notwithstanding your good intentions. And under Section 4, which seeks to criminalise the purchase of sex. Furthermore, the lack of consent has been raised by many deputies on both sides of the House. And also, the Society for the Prevention of Cruelty to Children has raised the continuous use of language like child pornography, rather than more specific language, child abuse materials and images. I will return to these points before I finish, if I have enough time. Firstly, however, on a more general level, this is a bill which unfortunately has had a very long gestation period, notwithstanding the urgent necessity to protect children, particularly given our obligations to do so under the Constitution, our international obligations under various legal instruments, legislation and conventions, and given the current lacunae in our current legislation. Gaps which were highlighted as far back as 2007 in a special report by the Special Rapporteur on Child Protection, Dr. Geoffrey Shannon. And that report highlighted the need for reforming the law in a number of very specific areas, which it has taken 9 years. And this bill is finally addressing those areas, and I very much welcome those changes without hesitation. In addition, as far back as June 2012, the Department of Justice and Equality opened a review on the law in relation to prostitution and then followed the Oireachtas Committee hearings. In addition, many organisations, including Bernardo's, the Irish Society for Prevention of Cruelty to Children, the Children's Rights Alliance, amongst others, have called for this legislation to go through the Oireachtas with speed, and I can see why, given the wide-ranging provisions contained therein to enhance the protection of children from sexual abuse and exploitation, including the protection against online grooming and more comprehensive definitions, and the inclusion of new offences, including the provisions for a harassment order. There's a reform on the law of incest with gender imbalance addressed. There's enhanced protection for child victims of sexual assault in the criminal process. Indeed, the absolute prohibition on the cross-examination of a person under 14 years by an accused person in a criminal trial is a major step forward, and with the judge's discretion remaining in relation to prohibiting cross-examination by the accused of a victim between the ages of 14 and 18 years. And indeed, this protection and this prohibition on cross-examination by an accused of a victim should be extended to vulnerable persons. And I think that has been acknowledged by the Government, that they will look at that. There is also welcome regulation of disclosure of third-party records, although again concern has been raised in relation to this disclosure, how extensive it will be, but more importantly, whether it will serve to inhibit children and adults coming forward for therapy. Thankfully, the bill in section 17.3, subsection 8, also addresses consensual peer relationships through the introduction of a proximity of age, a defence of 2 years. Under this provision, a person charged with an offence of engaging in a sexual act with a person between the ages of 15 and 17 years can rely on a defence where the act is consensual, non-exploitative and the age difference is no more than 2 years. Again, this is a most welcome new provision, more accurately and honestly reflects the real lives of young adults and teenagers on the ground and ends the criminalisation of young males. There are, of course, a number of areas, before I come to the two specific areas, and again, the ISPCC, while welcoming the bill, they highlight a number of concerns. Again, the absence of a definition of consent. Again, they raise concerns in relation to the disclosure of therapy notes, and I hope that's looked at and their concerns taken on board at the next stage of the bill. And I've already mentioned that they've asked that pornography, that word not be used, and you actually use more specific language that clearly shows what is going on and the abuse of children. Also, the bill completely omits any reference to or provisions for the risk assessment, treatment, monitoring or management of sex offenders. Again, I understand the Minister has stated that this issue would be dealt with in further legislation in early 2017, and this should be progressed as swiftly as possible, as this proposed legislation is also essential in ensuring that the children and the public are better protected from offenders who seek to prey on them. Finally, the bill does not deal with other offences such as stalking and victim shaming, and additional legislation is needed to address this. More specifically then, let me deal with two serious concerns that I have. Part 3, Sexual Act with the Protected Persons, and in particular sections 20 and 21. That's Part 3 of the bill. The Centre for Disability Law and Policy at NUI Galway, together with the Disability Federation of Ireland, Inclusion Ireland and the Irish Mental Health Lawyers Association, amongst others, are concerned that Part 3 of the bill does not respect the human rights of people with cognitive disabilities. And I say that knowing that the Government has come forward in a bona fide manner to try and protect vulnerable people. But if Institutions like the Centre for Disability Law and Policy, together with all the others that I've mentioned, plus the Irish Human Rights and Equality Commission, if they're raising concerns, I think we have to listen to them with their expertise in this area. Section 21 of the bill creates a new sexual offence which only applies to complainants with mental or intellectual disability or mental illness. People with disabilities in Ireland have campaigned for many years to have disability-neutral sexual offences legislation. Disability-neutral. And they do not want to see a new offence introduced which further stigmatises and marginalises people with disabilities. More specifically, they identified 3 key problems from a human rights perspective with Part 3 of the bill. While fully aware that the bill is one of the final pieces of legislation the Government has committed to introducing in order to enable Ireland to ratify the UN Convention on the Rights of Persons with Disabilities, nevertheless, they are seriously concerned that the bill, as it currently stands, is not consistent with the human rights principles as set out in the Convention. They identified 3 key problematic areas, and they go further and they offer 3 positive solutions or amendments. In relation to Section 21, which creates a specific provision which applies only to survivors of sexual violence who are people with disabilities, which the provision labels as protected persons. This is problematic because it implies that people with disabilities should be treated differently than others when it comes to their consent to sex and sexual activity. And the consequences of this provision is that it creates or constitutes and it builds in a disability-based discrimination into the legislation, I'm afraid, whether you like it or not. It's building in discrimination, which is prohibited under the UN Convention on the Rights of Persons with Disabilities. Their solution, a more human rights compliant approach, would be to introduce a disability-neutral offence of abuse of a neutral offence of abuse of a position of authority or trust. And apparently this was proposed by Minister Catherine Sapone, going back at the previous committee stage of this bill. And this would ensure that people who might be targeted for sexual exploitation based on perceived vulnerability, including disability, would be adequately protected by the law. And further, a sentencing uplift or enhancement for crimes motivated by bias against persons with disability could also be introduced if we seriously want to protect vulnerable people. Problem 2 identified by these various groups. The definition of the vulnerable person relies on a functional test of mental capacity. This definition is inconsistent with existing legislation, I'm afraid. It's inconsistent with the Assisted Decision-Making Capacity Act 2015, which was a very welcome act, as that act recognises that anyone at any stage might lack mental capacity to make a particular decision, regardless of whether or not the person has a diagnosis or label of mental or intellectual disability or mental illness. The use of a diagnostic criteria in this definition is both discriminatory towards people with disabilities and, equally importantly, it's under-inclusive of people who might be vulnerable for other reasons for sexual exploitation. People who have no diagnosis of disability may nevertheless be shown to be unable to consent to sex. Their solution? Define consent to sex in legislation, and again we're back to the absence of a definition. A more human rights compliant solution would be to ensure that a comprehensive definition of consent to engage in sexual acts is provided in legislation. The third problem, and they give a solution, is the reversal of the burden of proof on the defendants. And this is a fundamental change in our law. This bill provides that it shall be presumed, unless the contrary is shown, that the defendant knew that the victim was a protected person. This reverses the normal burden of proof on defendant in criminal cases by starting with the presumption that the defendant knew that the victim lacked the capacity to consent to sex and required the defendant to prove otherwise. In addition to this approach, seriously restricting the rights of defendants, it will clearly reinforce the stigma and the stereotypes about people with disabilities and that they lack the capacity to give consent to a consensual sexual relationship. The solution, they suggest, is to remove this reversal of proof from the offences. If the Minister's goal is to ensure that anyone engaging in sexual acts with people with disabilities takes steps to ensure that the person is truly consenting, this can be better achieved through a comprehensive legislative definition, and we can't get away from this absence, of consent to sex, which applies in all rape and sexual offences cases. Additionally, the Irish Human Rights and Equality Commission has reiterated that clear guidance from the Director of Public Prosecution on the circumstances in which a prosecution will be taken under the bill if it becomes law will assist in mitigating against the real danger of persons not entering into sexual relationships for fear of exposing themselves to a risk of prosecution. Accessible information on how the law will be applied should accompany the DPP's guidelines. Now, there are the three gaps and three problems highlighted in relation to Section 3 of the bill. Section 4 of the bill consists of three sections. It is the section that has drawn the most talk and debate in the Dáil. And yet there are 50 sections in this bill which is very well drafted and extremely important. And there is a page and a half in relation to the criminalisation of sex providers, amounting to 3 sections. Leaving aside Section 3, which hopefully can be remedied, I would say that the simplest thing to do here is to leave out those 3 sections, that page and a half, because I have no idea why they're in a bill seeking to protect children in the first place. I think it has been said already that the government is attempting to cover too much in the bill. So out of 50 sections, to leave out 3, I think would be the most sensible way to go about this. And then look at that whole subject separately in separate legislation, particularly in view of the fact that what you're proposing here is to criminalise the purchase of sex. I am not justifying prostitution. I am not justifying or making a judgment in relation to it. What I am most concerned about is, will the legislation serve to protect sex workers, which is your intention? And unfortunately, after reading all of the research, my conclusion is that it won't. And if you read the up-to-date research in relation to Northern Ireland, if you read the up-to-date research in relation to Norway and Sweden, if you look at senior counsel's opinion, which I must say very often in the Dáil we lambaste the legal profession, often rightly, and we lambaste the judiciary, the senior counsel's opinion was given on a pro bono basis. He actually outlines in the beginning of his opinion that those who commissioned him to do the opinion probably wouldn't like what he was going to say, because he absolutely was of the belief that the criminalisation of the purchase of sex was the way forward.
One minute left, Deputy.
1 minute, thank you. After looking at all of the research, he came to a different conclusion. And he said that there are serious concerns here that the criminalisation of the purchase of sex will lead to safety issues, health issues in relation to sex workers. And this has been backed up by the Irish HIV, which I implore you to look at, and the implications for health. Finally, I think speakers have conflated human trafficking with sex workers. And let me say that human trafficking is absolutely abhorrent. And it would seem that it is the third most profitable trade after arms. And I forget actually what the first one was. It'll come back to me. However, it's important to say that the conflation of trafficking with the purchase of sex, they're two different issues entirely. I absolutely abhor it. I think the government should be coming back to us to outline how they have enforced the existing legislation and so on. My final comment is from the Oireachtas report. 90% of women want to leave prostitution and leave as being a sex worker. There are no exit strategies in this legislation. There's absolutely no positive steps taken to help them to exit. And finally, the final, 90% come from exceptionally vulnerable backgrounds, whereas 90-something% of the clients come from middle to upper class backgrounds, and most of them are married.
Thank you.